Welcome back to Market Day Report. Happening now, the Supreme Court is preparing to hear oral arguments in a glyphosate lawsuit that could have big implications for agriculture. The case is centered around the herbicide Roundup and is one of thousands filed over the past decade. And the decision could impact all crop protection products. Richard Gupton with the Agricultural Retailers Association joins us now with an update. So we appreciate your time this morning, Richard, especially with a lot happening today, of course. So, I mean, glyphosate has really made headlines for the last couple of years. So some could say maybe this is a long time coming. But when it comes to this case in general, what's the crux of this current case?
Well, yeah, this case is not about a single product in glyphosate. It's really about who sets pesticide labeling standards in the United States. Agricultural retailers and applicators are legally required to follow the EPA-approved label. That's the federal standard. Exactly, and there's no addition or changes. And so FIFRA, which is the Federal Insecticide, Fungicide, Rodenticide Act, which has been in the law for decades, was designed by Congress to ensure pesticide labels are science-based and uniform nationwide. And what we've seen is state tort law or trial courts are kind of trying to take over in this area and say the EPA warning labels were inadequate and really undermine the uniform labeling system that we've had for decades.
And I want to talk more about that act that is in place that has governed the labeling and use of pesticides for decades now. Can you speak a little bit more about that process and the importance of uniform labeling?
Yeah, so these recent court rulings, and it's occurred in state courts across the country related to glyphosate, as you said. In this case, Monsanto versus Durnell, which the U.S. Supreme Court is going to hear in oral arguments later this morning. It really allows state jurors to second guess the EPA science. It creates conflicts in laws. Manufacturers, ag retailers, and farmers are required by law to follow the label, the EPA-approved label, and this undermines that. So if the state tort laws and these rulings are allowed to stand, it's going to really jeopardize not only glyphosate, but the future other pesticide products in the country and availability for farmers. It'll increase potentially insurance costs and, again, create chaos throughout the ag sector.
Yeah, you talk about how this could jeopardize a lot of these products that our farmers rely on. Do you see this case currently before Supreme Court potentially impacting this system?
Yeah, it'll have a major impact on, why would you want to invest significant amount of dollars in pesticide products if you couldn't stand by the EPA-approved label? I mean, there's already, we have cooperative federalism. A state does not have to approve a registration for use. Also, if you looked at the over-the-top dicamba case, right, if you want to challenge the registration itself based on the science, you do that. And that's what we've seen in other court cases. That's the proper way to handle this case, not through state tort law. And so we're hopeful the U.S. Supreme Court reaffirms the federal uniformity of these decisions by EPA following the science and not second guess that. So if they do, if it goes the wrong way, you're going to see a lot less investments in pesticide products, a lot less tools available for farmers. And glyphosate has been proven to be safe and effective for decades under EPA's regulations. And so we're hopeful that the U.S. Supreme Court will make the right decision here and go back to the standard that Congress approved for the last several decades.
Yeah, you talk about how EPA obviously says that it's safe for use, just like everything that our farmers use, of course, right? So you talk about what this means for farmers. What ripple effects could there be for the ag supply chain as a whole?
Well, again, you're going to have less companies wanting to make those investments. It puts them at liability. The insurance costs for retailers and applicators applying those products, not knowing what's going to happen with state tort cases. They, again, aren't necessarily based on the science that EPA has rigorously reviewed and looking prospectively that these are safe products to utilize. And so it's a lot of concern, really, the industry looking over its shoulder when they're trying to do the right thing, use products that have been legally approved for use by EPA. And I'm a lawyer myself, and I always tell them follow the label, follow the law, which has been the standard. And if the tort rulings are allowed and the state court cases are allowed to stand, that puts all of that in jeopardy.
Yeah, you talk about hoping that the Supreme Court makes the right decision, but we don't have a crystal ball to say exactly what this will mean and what ripple effects it will have. So is there anything the industry should be doing leading up to the court's decision?
Well, keep your fingers crossed, but also engage with Congress, engage with EPA, because these decisions matter. And right now that the Congress is looking at pass a House Farm Bill this week, there is language in there to reinforce the uniform labeling provisions. And so we're hopeful that that can be included in the Farm Bill. But if the U.S. Supreme Court makes the right decision here after the oral arguments today, they should have a decision by this summer. Then that should help put to bed all these state tort cases and create some long-term certainty in uncertain times right now for the ag industry.
I was going to say, I think long-term certainty is music to a lot of people's ears and what we're really leading towards, of course, right? So, Richard, thank you so much for joining us as we prepare for this case and looking into that this morning. Richard Gupton with the Agricultural Retailers Association.